did was collect the half-breed rolls. So we have several hundred, thousands. We have thousands of names now. And just as one example, the Old Crossing Treaty of 1864, which is with two bands of DeSoto people, the Red Lake and the Pembina bands. There are over 400 Métis listed on half-breed rolls. All of them with names that come from this region and also come from communities further west. Red River, Montana, Saskatchewan. So Fayence, Laframboise, Deschamps. And the whole point of the half-breed rolls, well, I think there are several points. One is to enumerate them. One is to understand who they are and to distinguish them from what they consider to be the Indian population. And Indians negotiated for annuities and for the reservations, which consisted of 640 acres usually for a family of 5. The Métis in this case would not receive annuity payments, but they would obtain the right to obtain scrip. And scrip is simply a slip of paper that entitles you as an individual to 160 acres of land as freehold tenure. One of the things to be careful about even in Canada, with this whole treaty and scrip or half-breed rolls things is that this is not necessarily a clear identifier that somebody is self-declaring as Métis or half-breed. What they're saying is, I would rather take 160 acres of land as an individual than be stuck on a reservation. Or I'd rather be on the reservation in a collectivity and not leave myself open to the possibility that I'll lose this 160 acres of land. Right? These are, one of the issues of terminology is that identities shift over time, and what we're seeing in this era is identities are being shaped and manipulated by legal requirements, by American and Canadian governments that are saying, you have to now make a choice. And one of the reasons not to take treaty in the United States was that the treaties were then used as a mechanism for removal. What starts happening to the tribes in the southern Great Lakes is the removal era comes, and anybody who's on the treaty list is subject to removal into the Indian territories and away from their homelands. And people start to take the half-breed roll side as an option because the half-breeds are not removed. Those people remain exactly where they were when they began. And maybe cross back onto the Canadian side and become involved in the Treaty 3 negotiations, maybe go to Red River and become involved in the scrip negotiations. We see people in multiple points over time. So at Old Crossing, just to pull out a couple, there were 2 Landrys. Charles Landry is on the half-breed rolls as number 24. And number 474 was Alexander Landry. I don't know anything more about them. We're just starting to sift through all of the data from the half-breed rolls to try and figure out who people are and how they're connected. And maybe they're not, but chances are pretty good. The American Fur Company, like the Hudson's Bay Company, keeps rosters of people that it employs. And so if we start going through the American Fur Company registers, this is for Mackinac, we start to see the range of names: Folios, Bergers, Londos. So we know that people are being employed by the American Fur Company. And the Minnesota American Fur Company trading territory is quite extensive. It extends all the way west into the Red River Reef Basin. And we start to then, Jason brought this up, these are communities that are separated geographically, he didn't say it quite this way, but they're separated quite geographically, and yet we start to see people hopping to very specific locations because the trade networks pull them into those locations. This is what they do for a living. We have other things. Schoolcroft did a basic enumeration. These are the numbers that he gave in specific locations for half-breeds. 140 at Mackinac, 304 at Pembina, 16 at Rainy Lake. There are no names associated with this. These are just raw numbers. So we don't know what methodologies he's using to capture this population. You know, how is he deciding who's Métis or half-breed, and how is he deciding who's Indian? I don't know the answer to that because he doesn't articulate that. But it's a starting point. So we have the nice thing about technology, which I don't work very well clearly, but that's why we have grad students, is that it allows us to do new things with old data. It's not really that the data didn't tell us anything, it's that we didn't have interpretive tools that helped us use it very well. And as we've been refining our own work, we've been moving through this process of finding new ways to tell different stories. It became clear to me when I did the Northern Saskatchewan research that the godparents were important. I just didn't know how to use that data because the method I was using, which was genealogical, didn't permit me to do anything with that data. And so I kept very careful track of who was godmothers, how often, was it their families, were they moving in other families, same for godfathers. But fundamentally, there was no way to really reveal patterns. And then when we discovered this social networking software, we're finally able to start exploring it as a possibility. So the material's always been there. We now are starting to think about new ways to pattern it so we can actually visualize it in different ways. So it's a work in progress. We don't know where it's going yet, but I thank you for your time, and we can talk later. Thanks.
All right, thank you. So we will have time for a question and discussion after our final speaker. And our final speaker for today is Jean Hayet. Jean is a Métis lawyer who specializes in Aboriginal rights litigation and negotiations with a particular emphasis on Métis rights. Jean was lead counsel in the Powley case, which was the first Métis rights case to be heard in the Supreme Court of Canada. She was co-counsel at the Supreme Court of Canada in the Captain River case, which established, along with the Haida Nation case, the consultation and accommodation rights of Aboriginal peoples. Jean also publishes Métis Law in Canada, which is an annual update and comprehensive look at Métis law as it develops. Jean Hayet is a great-grandniece of Louis Raymond. And if I may share another anecdote, when I was in law school, the University of Toronto Faculty of Law unveiled an exhibit that celebrated remarkable women graduates who are trailblazers in the legal profession. Jean Hayet was selected as one of those trailblazers. I can't overstate how inspiring and affirming it was to walk past that exhibit each day on the way to and from class, and to see Jean's accomplishments as an Aboriginal rights activist listed there on the exhibit. So please join me in welcoming Jean Hayet.
Brenda has grad students, I have Jason. I just wanted to say one other thing because I'm so fascinated by this social networking, so this isn't about my talk, but one of the things that is a debate that's going on in the Métis Nation, a very vehement debate for the last 10 years, is about adoption and whether you should be able to adopt children in and bring them into the community. And from my perspective, I think that godparenting is a huge issue in that, because it's very hard to go back in the records and see adoptions, but godparenting was a way of achieving that very thing. So, and I don't think that's very well understood today, in this day when our secular age and godparenting doesn't mean the same thing that it did back then. Anyway, I'll get back on my get off Brenda's topic. I thought that today, because today's such an auspicious day, it is the 30th anniversary of the Charter of Rights and Freedoms being brought into force and effect in this country, but it's also the 30th anniversary of Section 35. And so I've been asked to participate in a big conference on this at York University in the first week of May, and I've been working on this, so I thought I'd give you a shortened version of the paper and notes. I don't know where the game is.
Oh, use the keyboard, the arrows on the keyboard.
Oh, thank you. Okay. All right. So So I think before you want to understand, we all talk about it. I'm so astonished when you talk to Aboriginal people around. We rattle off numbers like you wouldn't believe. We talk about Section 35 and Section 9124, and I'm a Section 6D of the Indian Act, and we just rattle off these numbers as a shorthand way of talking, and they comprise a big depth of knowledge of history and everything all rattled up in them. So we talk about Section 35 all the time. And yet, the other thing that has become very clear to me is that we're not very good at keeping track of our own history, of our own history and our own people, but even our legal history. So it occurred to me that before we talk about what Section 35 means today, you should know how Métis got into Section 35 and a little bit of the history of Section 35, because I suspect there's quite a few people in this room who don't know this history. Some of you weren't born yet. That's not shocking to me. But some of you weren't born yet, and some of you probably never knew the story. So this is the original language for Section 35. So it's not the language we have today. This is and I should actually say that it wasn't originally Section 35. I think it was Section 32 originally when they were first drafting it. So you're talking about 1981, okay? So this is before it becomes solidified, and that's what it said originally, that the Aboriginal and treaty rights of the Aboriginal peoples of Canada, as they have been or may be defined by the courts, are hereby recognized and affirmed and can only be modified by amendment. That was the first drafting of it, right? So later on, when we start talking about whether Section 35 is an empty box, meaning, or a full box, empty box meaning, according to government, that it doesn't have anything in it until the courts define it. That's where they get that idea from, is right from here, from the first draft of it, okay? So this is the form of the clause that was before the joint Senate House of Commons committee hearings in January of 1981, and this is the famous story of how the Métis got into Section 35. But that was the draft clause, and standing in the hallway before they go into the Senate hearings, Jean Chrétien, who was then, before he was the Prime Minister, he was the Minister of Indian Affairs, is walking by. Harry Daniels accosted him. Some say that he grabbed him by the shirt collar. Others say he was left leg. I knew Harry pretty well. I'm not sure he didn't grab him by the shirt collar. But anyway, Harry sort of cornered Chrétien and said very, very clearly to him, the Métis are Aboriginal, you have to put them in by name. The Indians didn't want it, right? They fought it, they were fighting the inclusion of the Métis by name, they didn't want it. Harry insisted on it. Standing right by was Sven Robinson. Sven Robinson was an NDP MP from British Columbia, and he grabbed a napkin or a piece of paper and he penned the bottom bullet, which is now Section 35.2. Aboriginal peoples includes Indian, Inuit, and Métis. Now we have Métis peoples of Canada in there, but this was the first draft that Robinson said here, gave it to Chrétien. Chrétien went into the Senate hearing, and so what happened then was that's what they adopted there. That was the idea. That was going to be the Aboriginal clause in there. So then what happens is there's a lot of political going back and forth. A lot of this is wrapped up with women's rights issues, right? Because there was also an equality clause, the Section 15 of the Charter about the equality rights for women. There's a lot of bartering, there's a lot of the Western premiers, particularly the conservative premiers in Manitoba and Alberta, hate the Charter. They hate it. Actually conservatives hate it generally. There's a good reason why you don't hear Prime Minister Harper today celebrating the 30th anniversary of the Charter, right? It's because they don't like it. They want parliamentary supremacy, not unelected judges to be determining law in this country. So they don't like the whole idea of the Constitution. At the time, it was Lakehead and in Alberta and Dufferin in Manitoba. So in between February of '81 and the end of the year, Dufferin loses his election to the NDP, right? And and Peter Lakehead is persuaded to believe that if we put existing rights in, that will somehow lessen the meaning of it. There's a lot of back and forth. There's public outcry from Aboriginal leaders, from churches, from women's groups, all over the map, because in the argument they had removed the Aboriginal Rights Clause and they had removed the Women's Equality Clause, right? So you have about 10 months of political fighting. A lot of elections, a lot of people being re-elected, things change. By the time you get to November, both those clauses are gone. Justice Tom Berger vehemently protests. He was a judge. He gets booted off the bench for daring to speak out for Aboriginal people in public. I don't think that would happen today, but it certainly happened then. So as a part of this big protest, the Women's Rights Clause and the Aboriginal Rights Clause come back in, and they come in the form that you see today. So you see the reference to the courts is gone, and existing is in, and Métis are in. And so you get to, that is the way Métis end up in the Constitution. Now, our constitutional provision didn't stop that day, right? So what happens in 1983, we amended the Constitution, and we added 3 sections, Section 35.3, 35.4, and 35.1. So 35.3 is about the fact that if you go back to the original wording, you'd see it says the existing Aboriginal and treaty rights. So, but we were all engaged in land claims negotiations in the north, right? And so it was, but we were calling them land claims negotiations. We weren't calling them treaty negotiations. So there was a big concern about whether that would be included in Section 35, and could we negotiate new agreements that would be protected by Section 35. So Section 35.3 is added specifically to make sure that those new land claims agreements are going to be included in section, protected by Section 35. And then we have another equality rights clause added in with reference to Aboriginal people, because nobody was sure whether Section 15 of the Charter would apply to Aboriginal women under Section 35. So this is the let's lock that down kind of clause, right? Okay, 35.1 is about the constitutional conferences. So let me tell you what happened is, let's go back to the clause. Everybody started saying, well, what does that mean? What does existing Aboriginal treaty rights mean? What does Indians mean? What does Métis mean? How do we know what any of these things mean? So the solution was, because they wanted to get the Constitution down and ratified. Remember, Quebec's bubbling around in the background here, right? You know, and Trudeau wanted this wrapped, right? So they decided to wrap it, and the way out is, and this is typical lawyers, right? If you can't solve a problem, set up a process to solve it later. That's what they did. We'll have constitutional conference, and we will then determine all those things that we can't do now. We'll figure out who the Métis are, we'll figure out what Aboriginal and treaty rights are, and so, but the Aboriginal people wanted the promise in the Constitution. So this gets put in the Constitution, a guarantee that we're going to have this constitutional conference, and that the Prime Minister is going to invite the representatives of the Aboriginal. So they're not going to decide it. In other words, the premiers aren't going to get together around the table and no Aboriginal people will be there. So there's a guarantee that they'll be there. So they then have in Section 37 a statement that it's going to happen within 1 year of April 17th, 1982. And here's the agenda items are going to be the identification and definition of the rights of those peoples to be included in the Constitution, and representatives are going to be invited. So this is written into the Constitution. You won't find it today. You'll just find something that says deleted, right? Section 37. But in the footnotes and everything, it'll tell you the history of this. So then there's a later amendment to Section 37 that ups it and says that they're not just going to have one constitutional conference, they're going to have 3 constitutional conferences, and that the first one's going to be, they're going to have the first one within a year, and then they're going to have another one within 3 years, and then another one within 5 years. And again, there's going to be representatives in it there. So the date of the first constitutional conference is drawing near, and okay, who is going to sit at the table, right? Oh my goodness. For those of you who are around it, you might not have been aware, because this actually wasn't in the papers very much, the big debate about who was going to sit at it. But in Aboriginal political circles, it was a big, big discussion, right? So throughout the discussions leading up to 1982, Harry Daniels was the forefront leader. There's absolutely no question about it, as Brenda was saying earlier today. And we make it a point, I make it in my Métis law summary, I have a picture of Harry, I make a point of that we should recognize the fact that it was Harry Daniels who got the Métis in the Constitution. Despite the fact that lots of people want to take credit for that now, other people who were there, it was Harry who did it. So, but what happened is after 1982, you should remember that this was the Native Council of Canada. So let me talk about the Native Council of Canada. That was actually established in the late 1960s, established by Métis on the prairies. And it was established by them to further their political agendas about land claims and Aboriginal their rights and all the things that Métis have been upset, script, all the things they've been upset about for a long time. And then what happened was the non-status Indians came to the Métis and said, yeah, but we've got a bunch of issues too, mostly about all the women who had been knocked off the Indian Act lists. So how about if we get together and we work together towards this? So the Métis said, okay. And they brought the non-status Indians into the Native Council of Canada. So I think it's important that you understand that the Native Council of Canada was created by the Métis. Was not created by non-status Indians who later brought in Métis. It's the other way around. So the most important thing for the non-status Indians was regaining their status under the Indian Act. So this is important because after 1982, Harry Daniels, who's the head of the Native Council of Canada, which has this mixed membership, gets voted out. Right? He's no longer the president of the Native Council of Canada, and Jim Sinclair takes over. Jim was, well, Brenda said people have fluid identities. I think Jim fits into that category. At that time, he wanted to be an Indian. So Jim became the president, and so what happened was in the time leading up to the 1982 conference, the Native Council of Canada elected a new board of directors and a new president, and they then were in charge of who was going to sit at the Constitutional Conference and represent the Métis. And they said among themselves that they weren't going to put a Métis representative there because Métis issues were secondary to the most important issue, which was them getting their status back. So they selected two non-status Indians to sit at the Constitutional Conference table. Well, you can perhaps, all the Métis in the room will know that Métis don't take some things quietly. And so, as you can well imagine, the Métis who were in the Native Council of Canada were, not to put it too politely, pissed off. And so Clem Chartier led them out of the room and straight to an office where they drafted some bylaws, went to I think it was Industry Canada at the time, and incorporated something called the Métis National Council, which was dedicated to be a Métis-only organization. No Indians, no, it's actually written in different ways into the bylaws. And they then went to the Prime Minister and said, we want a seat at the Constitutional Conference, and they were soundly rejected. Because up until then, they'd always been dealing with the Native Council of Canada. And so Clem then went to a lawyer in Ottawa named Jean Richard, who was subsequently the Chief Justice of the federal court, but at the time was just a lawyer in Ottawa. And so he filed an injunction application, and they slapped it on the federal government saying you can't go ahead with these conferences because you guaranteed in the Constitution that the representatives of the Aboriginal peoples of Canada would be there, and you've just set it up so that the Métis are not represented, and that you're violating the Constitution. If you don't do this, we're going to shut this Constitutional Conference down. So Chrétien, not wanting to shut it down, agreed and split the non-status Indian and the Métis seats, and he gave 1 seat to the Native Council of Canada for non-status Indians and 1 seat to the Métis National Council for the Métis. And that is the way, it was an out-of-court settlement. That's how the constitutional conferences went forward. Now, after all that, one would think that they might actually do something at those constitutional conferences, right? But the truth is that they all resolved down to nothing. There was a lot of talk, and they foundered basically on 2 big issues. One was self-government, the idea of self-government, whether Aboriginal peoples had self-government, whether that was an existing right within Section 35, and the other one was on the whole idea of identification. Who's who? Are non-status Indians, are Métis, who's Métis, all of those issues. And as you can see, we've spent many, many years doing research and work, and we're still not resolved on those issues. I think it was superbly naive of anybody to think that you could resolve those kinds of issues at a conference, right? Of politicians, mind you. You know, no historians or people who are experts on this to be seen, right? Just a bunch of politicians in the room. It was probably never, in hindsight, I think that, you know, hindsight's a wonderful 2020 lens to look through, but they were quite optimistic at the time, but clearly nothing happened of it. So what happened then is all that work. See, Section 35 is just a skeleton, right? All it says is existing Aboriginal and treaty rights, and here's the names of the people, but there's no flesh on those bones. There's no meat there. There's no way to understand the depth, and that's what needed to happen. And so the fact that it didn't happen at those constitutional conferences, and it's not, that left it really to the courts or to further constitutional conferences. And the next constitutional conference, because of the way, the constitutional dialogue, because of the way those conferences had foundered, they just went, oh, we're not going anywhere near these Aboriginal issues. We're going to solve Quebec. Quebec's, you know, because even though I've been talking about Section 35 in the Charter in terms of Aboriginal people, you cannot forget that the biggest issue in Canada was certainly about the fact that Quebec was not on site for bringing the Charter in, right? Meech Lake was all about bringing Quebec in. Aboriginal people were so second back of the bus, they weren't even on the bus, right? There was no invitation to sit at the table. They didn't participate in anything. It was all about Quebec, and Canada, this is Mr. Mulrooney by this time, paid very dearly for that, because in the end it was Elijah Harper sitting there with his eagle feather in Manitoba who stopped Meech Lake, right? Because the provinces had to ratify. Now, it's true that Newfoundland also didn't ratify it, but ask anybody in this country if they remember that Newfoundland was actually played a role in this. They don't. In the big Canadian consciousness, everybody sees Elijah Harper sitting there with his eagle feather in the Manitoba legislature saying, no, right? So what happened is, and that wasn't an accident that Elijah Harper did that. Everybody, all the Aboriginal people were behind the idea that Meech Lake had to go down because they had left Aboriginal people out. So that was round one after. Round two, Charlottetown, okay? This time, Mulrooney's not gonna leave the Métis and the Indians out, and they're all gonna come to the table, and we're gonna bring everybody in here, and we're gonna fix this thing, right? So they're included in the discussions and the debates, and in fact, had Charlottetown been approved, it would have been a huge step forward for the Métis, because there was something called the Métis Nation Accord attached to it. It had a basis of a definition, had an agreement that Métis would be included in 9124. It had a promise of negotiations towards self-government. It was a very, very forward-looking document. And then the people of Canada rejected Charlottetown. So that went down, and what we've played with since then is that the federal government thinks that constitutional discussions are somewhat like the measles, or, you know, I don't know, the plague. They're not going anywhere near them. That, you know, after Meech Lake and Charlottetown, they've had it. And so all those issues that we thought should have been resolved through those constitutional means were left to the courts. And that's where we're at right now. And I think that what happened was that Métis sustained a belief all through that period. So you're talking about from 1981 to basically 91 in Charlottetown, right? 10 years. Métis sustained a really big belief that that it meant something. Section 35 meant something, you know? We thought it meant something, that surely getting our Aboriginal rights in there had carried some meaning. And it took quite a long time for it to sink in, reality to sink in, right? And you're probably guessing where I'm going with that. But I think what we began then is what we call the full box, empty box debate. You know, you got predictable versions of it. The government says, no, Section 35 is an empty box until the courts make a decision, and then whatever right they recognize goes in the box. And only is very narrowly thought of. Métis say, no, come on, you know, this is a crazy way to do it. So that judgment's been going on for a long time. Ian Binney, who was at the time a federal Department of Justice lawyer, right after, and this is in 1990 even, when someone asks him whether Section 35 has any meaning and he says no, he's greeted by a whole room of hundreds of people with outright laughter. They just can't believe that these words can come out of his mouth, right? He then gets appointed to the bench in the Supreme Court of Canada, right? And we all went, oh no! Look, this is the guy who doesn't think Section 35 means anything, and he's going to be sitting on the Supreme Court of Canada. Well, it's interesting because he turned out to be one of the better Aboriginal sympathizers on the court. But the Métis National Council also got a letter from Jean Chrétien saying that Métis rights didn't exist and they'd all been extinguished, and Section 35 didn't mean anything for the Métis. We just put them in there to appease them. Right. So that's kind of what was going on, right? You know, so we had an expectation, and we were not alone in that. I really have to emphasize that. Aboriginal people thought that Section 35 meant the government would take action. We thought it would mean that because these things were there, government would change their laws, they would change their regulations, they would adopt policies, they would do things that would change it. Now, when I said we're not alone as Aboriginal people in thinking they were going to change it, the people of Canada thought that too. The women of Canada thought that that Section 15 equality clause meant something, that they would get equal pay for work of equal value, that those kinds of things would happen. People thought freedom of speech in the thing meant something. People thought the right to not be arrested with, you know, without a warrant, all those kinds of things. We thought that meant something in there. It didn't occur to us. It never occurred to anybody in this country that governments across this country would act as if the Charter and Section 35 was one thing and one thing only, a right to go to court. And that's what it has become, in fact, is a right to go to court. So there's a silence from government. They took absolutely no proactive steps on any level, not just Aboriginal rights level, but for us it was a big, very loud silence coming from government. So we've gone to the courts, and we began our litigation strategy in the mid-1990s. I'm not going to go through all the cases, but you know, we started in northern Manitoba and northern Saskatchewan. The provinces there didn't want to appeal them because they didn't want higher court judgments. We were winning. They didn't want to do that. So we ended up with the Powley case. And the Powley case, you know, most of you know, was the first case to actually get to the Supreme Court of Canada on Section 35. I should caution you that, you know, at first everybody was afraid to use Section 35. So right after, in 1982, there's a case rolling through the Guerin case, which is about fiduciary duty. And at that time, there was an option for them to argue Section 35 as an Aboriginal right on that it was Aboriginal right, their lands there. Everybody was very afraid of Section 35. They didn't know how to use it. We didn't know how to litigate it. So they didn't. They just walked away from it in Guerin. Now, so that's why Sparrow is the first case in 1990 to actually raise an Aboriginal right. So then we get Powley in 2003, and after that, I'm just trying to figure out where I am. I've been talking without looking at my notes. Right. I guess we know that Powley settled a few things, right? So the first one was that there were Aboriginal Métis existed, right? I mean, that was a very important thing. You have no idea, right up until the night before, even Métis leaders from the prairies were worried that Powley would come down and say that Métis didn't exist as a people, right? And it also clarified that Métis rights were to be respected equally on a farm and Indian rights. So those were very important things. Here's what happened after Powley. We ended up having to do what we call hectare by hectare litigation. We've been engaged in a whole series of cases. We've tried to negotiate agreements. The government doesn't abide by them. We have to take them back to court. We have governments, our agreements are subject to political whim. The one in Alberta, it's very interesting to us to watch the Wild Rose Party rise in Alberta right now, because Ted Morton, who was running for the head of the Conservative Party, who is to the far right of the Conservative, the far right of the Conservative Party at the time, and actually still is now looking like he's going to lose his seat because he's not far right enough for the Wild Rose, but he's the one who campaigned on a campaign of getting rid of the Métis harvesting agreement that we negotiated in Alberta. So, you know, the wheel spins, right, around and around. So we are doing our hectare by hectare litigation, and where charges are mounting everywhere, not in Ontario, but in Manitoba, Saskatchewan, and Alberta. We have, 20 charges. Some of the charges we have in Alberta, in Manitoba, are almost a decade old. The Crown won't take them to court. They won't litigate against them, but they just keep adjourning them and adjourning them and adjourning them. So what are we left with? We found out recently there's been a case that a Métis guy ran himself in Manitoba, Charles Beer, and is about harvesting wood. And what we found out in the case, and only because of disclosure at trial, is that Manitoba had adopted a Métis harvesting policy about what Métis could do and where they could harvest and everything. It recognizes Manitoba Métis Federation harvesting cards. Well, this was news to the Manitoba Métis Federation. Nobody told them. Nobody talked to them about before the policy was created. And if it hadn't been disclosed during the course of the trial, we still wouldn't know about it. So what disturbs me about this, and by the way, if you don't have a Manitoba Métis Federation card, you have to get on some shadow list that these bureaucrats are creating. On what basis, on what criteria, nobody knows. It's just this backroom stuff. So what I'm disturbed by this is not only are we going to court no longer to prove rights, we're going to try and draw arbitrary boundaries around arbitrary communities. We're going to court to prove that these fictional Métis communities that we're expected to find are a fact, right? So that's what we have to do. It's an impossible task. It's crazy making, trying to draw boundaries around buffalo hunters, right? What are you going to do? You say, oh, the buffalo went here, but he didn't go right over there. I mean, it's mad. And how do we know where the buffalo went anywhere? Anyway, right? There's just no way to know this stuff. So it's an exercise in futility. But what the problem is that we're developing this law, and a lot of this law is creating fictions, legal fictions, right? So elsewhere in Canada, we're having interesting things. So for many years in Newfoundland, we had a group of people who were calling themselves the Métis Nation of Newfoundland. Well, they've just decided that they're not Métis now. Okay, we've got case law on them now, because what do we do with that, right? You know, they've said, no, we're Inuit. Okay. All right, I guess you can change your mind. I never liked their principled reason for doing it anyway, calling themselves Métis, but okay. So we had Métis in Newfoundland for a while. Now we don't. And self-identification gives you an idea of how important self-identification is, right? As a factor, because it's not like the courts are telling them they're not Métis or the government's telling them they're not. They're saying now, we're not Métis anymore. So they said they were Inuit before, and then they said they were Métis, and now they're saying they're Inuit again. In New Brunswick, there'd been a whole bunch of people up trying to create them, and they can't even get their own experts to say that there's a Métis community historically there. So I don't think there's anything in New Brunswick. Quebec, we don't know yet. There's no data, no facts to deal with here. But, so just to wrap this up, I think that it's, 30 years exactly today since Section 35 came into force. And legally, I would say it has meant nothing more and nothing less than a right to go to court. The only good thing about Section 35 that I see is that it has influenced government to help Métis create institutions and cultural rules. But it's the institutions I'm most interested in, because in fact I think that it is the development of institutions which sustains the existence of cultures and people. And if you don't have institutions that sustain them, then there's nothing for people to gravitate to relate to hang on to, or to pass on in the future. And so the idea has been now, what's happening since the creation of Section 35 is that we're creating these registries. We're doing all this kind of work. We're starting to articulate, if not internal, we seem to be resisting internal boundaries within the Métis Nation. I think that's a good thing. But we are starting to kind of map out the under boundaries of the Métis Nation and starting to see where that exists. Now, I think they're very blurry, and I don't think maybe we should never draw a hard and fast fine line around it, but just get a general sense of where it begins and where it ends. And so because if you don't know who you are, how can you pass that on? How can you say we have rights? How can you be a self-governing entity if you don't know who you are? You don't know how far you reach, or how you go back in time, how you will go forward in the future. So I think that in the end, that bottom bullet is maybe, to me, the most important thing that Section 35 has come to mean to us. Is that, and the courts, our court battle and our negotiations has simply been a means of getting everybody, government, to help us do that. Sometimes it's just funding, but sometimes it's getting out of our way. And also, we're lucky we're doing it in this day and age, because if we'd been doing this in the 1900s, we'd end up with an Indian Act list, right? That's what we would have. And we're doing it. We're trying to create registries, but we're not basing them on look at what the Indian Act is. The Indian Treaty Commissioner walked in one day with a piece of paper, and whoever was there signed on, or the people who adhered later, those are the people who we call Indians today. They're descendants, right? It's very arbitrary as to where the end of that line was. So why are you in the Robinson-Huron Treaty as opposed to the Robinson-Superior Treaty? And is there any really big difference there? I don't know. Why is it that the Algonquins just on this side of it don't have a treaty versus some of the Algonquins who are on this side are in the treaty? We've got all these kinds of arbitrary lines here, right? We have an opportunity to do this without doing arbitrariness, right? Without doing it. And I think that's the most important thing that I take out of Section 35. And so then in the end, 30 years, I actually think we've accomplished a fair amount for ourselves in 30 years. When you think about the fact that the Métis couldn't even get a seat at the table, within a year of being included in the Constitution, they had to go to court to get a seat at the table. I think we've actually moved the yardsticks somewhat. So my old Uncle Roger used to say that things come in waves, and then there's a bit of a backtoe, right? But the difference is that you never quite go back to the beginning, right? There is some progress that keeps getting made, and that's what I see. I think we've moved a couple of waves down from there, and that's the result of a lot of hard work of a lot of people. But I think that if we are to keep those waves going, we have to remember where we started from, so that we can keep that going. Can't lose sight of the original starting place here, and how we would like to push forward in the future. So That's where I'm going to start. Thank you.
Great, thank you very much. Now we do have time for questions and discussion. Before we start, if anyone ends up leaving before the question period is over, I just want to let you know that everyone is invited to a reception at the faculty lounge beginning at 5:30. Okay, so with that being said, perhaps I can ask the panel to come back up to be available to answer questions. Now, I'm not sure if people asking questions can use the microphone to because it's including webcast, or is that not necessary?
You'll be just fine.
Okay. Right, so any questions from the audience?
No questions.
There's something. Yes, right here.
I just want to ask our last speaker, why are political opponents so afraid of Métis rights? When you have someone in Alberta whose platform is to eliminate harvesting rights, what's the harm in having Aboriginal harvesting rights? And why would someone run a political campaign on that? And when you have, Harris that said, I'm going to repeal, I'm going to, bring down the Powley case. Where's the fear in Métis people having rights in this country?
If you, this is just my own personal opinion, maybe the others have other opinions on it, but what I think has happened is that I think people like Mr. Morton, people of that ilk, don't like any kind of category of special rights. They want to see everybody as absolutely equal. And so the idea that the people who, now personally, I think he only thinks that because he lacks imagination. If Mr. Morton, if he could imagine himself on his ranch, which I understand he has in Alberta, and let's just say the Americans came over and took over Canada, right? And they do whatever they want. They build roads where they want. They insert their government. They import their Republican system of governance on top of ours. They get rid of our parliamentary democracy. They get rid of our land rules. They get rid of everything, and they impose their other one. And oh, by the way, Mr. Morton, that's a really nice piece of land. We're going to take that because our president wants it. He likes your ranch. We're going to set that up as his ranch here. So we're going to remove you, and you can go live over here. And oh, by the way, we still want you to pay taxes on that. So that's what we've done to the Aboriginal people, who were here first, living here on the land with their own laws, their own land, their own everything. We came across as the immigrants came, took all that land away. So the reason, but he wants to start the clock fresh, as if that didn't happen, as if the minute they came, okay, everything is going to be equal from the day he arrived, right? But afterwards, anybody who comes after that, no, it's all about the day he arrived, right? That's a very, very common attitude across the country. So they have been persuaded, some of them, that they can't get away with denying Indians the right. And okay, maybe the Inuit way up top, but nobody cares about them because there's nobody up there anyway, right? That's their attitude. So Indians, okay. But we draw the line at the end of the Indians. There's a line in the sand, and we are not going with this Métis BS. That's where they're at. That's what's going on out there, and I've actually heard them say that. So I think that's very clearly the attitude that is going on. That's the way I see it. I don't know if anybody else differs. No.
Thank you.
Yes, Senator Bob?
Yeah. I read somewhere just recently, well, the Métis Nation of Quebec, I understand are going to be signing an agreement or an MOU with the Métis Nation of Alberta. You know anything about that? Because I read it.
I don't believe it.
I read it in, I think in a newspaper somewhere.
I don't believe it.
Saskatchewan.
Yeah.
Métis Nation of Saskatchewan?
Saskatchewan.
Okay, it's Saskatchewan.
I
knew
see.
it was one of the third provinces. They're going to sign something with the Métis Nation, which is formed in Quebec.
I would take that up with your leader President Lipinski so that he can raise it at the Métis National Council.
No, I don't even worry about it. I think that would be great, to tell you the truth, because I'm for Aboriginals across Canada, and I'm not for, I'd like to see the United States define us Métis people that are living in the States. I've been on some of our ancestors who migrate up to St. Lawrence River, so I'd like to see that they can be called Métis too, not classified as an American Indian.
Kind of I follow the same question about how our neighbor deal with this kind of culture issue. From the academic point of view, and from what I learned today, is the integration of the two cultures lead to the generation of a Metis community. And that similar integration, I guess, historically would also happen in the United States. And if that's true, what do they call? They also call that Metis community, or they have a different name, or do they have a different recognition in the United States?
The Americans have historically not recognized Métis. They have the half-breed rules, but simply to run a different land system. But there is no legal category, and that, by and large, is because America is predicated on conversations of race, in particular African American and white. And so that racial conversation is about purity, and it's about maintaining the purity of those racial lines. And so the idea that you have, even in in any other ethnic group, the idea that you have people who cross those boundaries is really antithetical to the foundational intellectual thought of the United States. They struggle with it greatly. And you see that in even op-ed pieces from people who are biracial, African-American, white, that they struggle with this construction of race because they don't fit inside of that construction of race.
But what they have done, and so let's just, the U.S.-Canada border was not, the buffalo hunters didn't all of a sudden go, oh, we're going into Montana, better stop. Those connections, there are Métis communities in the United States. How they are dealt with, though, is they're identified as Indians. So you have, or white. And so you actually have reservations in the United States that the Michif language is spoken on them. The entire community, by and large, would be Métis. They're culturally connected to the Métis communities on the Canadian side, but they're actually established reservations, whether it be in Belcourt, what are some
Rocky River Reservation, Little Shell Tribe, Turtle Mountain.
So it's because they don't see that there's this distinct people. It's either you're Indian or you're white, and so we do actually have those examples of reservations in North Dakota, Montana. Same cultural connections, same kinship connections, but they're identified as Indian reserves.
I think that we should also say that the idea that Brenda's raising about racial purity is not restricted to the United States. It is one of the other reasons, which I should have responded to the question here, it is one of the other reasons why people resist recognizing Métis. Is there is what Manel Matani, she's a social geographer at the University of Toronto, calls a relentless negativity towards the very idea of mixed race. So, and that's mixed race individuals. So let alone a people, a whole people who are a mixed race. And so we do this in Canada too. We have a multiculturalism concept, but it's based on purity. So if you're fully Chinese and you come to Canada, we'll let you be in your multiculturalism thing. But if you're fully Chinese and you're, say it's the mother and father come, daughter marries a, I don't know, a boy from Iran, right? No multiculturalism policy anymore because there's this mixed race thing anymore. Multiculturalism, our multiculturalism doesn't recognize anything that is other than the pure thing. Now we have decided, only because Harry got Métis in the Constitution, that Métis are a purity in a sense, right? So, but the idea of which defies history because everything is multiplied.
And the interesting thing is history records half-breeds and Métis people because people are fascinated by the very idea of mixed ancestry, right? So everybody who, everybody who travels through recognizes them, and because they have that moment of something is weird, they kind of look French, they act French, but then they're talking Cree or Ojibwe. Something's not reconcilable here, and so that's why we have such great sources. We don't lack sources. We have great sources.
What do you do about the sources? We were talking about our genealogy being patrilineal, in the way we map our families through the father's line. And I've been doing that research for my own family with a great-great-grandfather that came over from the Orkneys to work for the Hudson Bay Company and married a Cree woman. Well, she has no name. She's just Indian woman. And it's like that throughout the record. So how do we find these women who are faceless and nameless in our records?
Well, that certainly does happen, and often they're given their Christian name at the point of marriage. They've been baptized at the point of marriage. You may never know who that woman is, but you start to find out where that woman came from, and that often is identified. She's probably from the place where they got married, but she's probably from the place where his first posting was. There's all sorts of ways to sort of guesstimate that. Sometimes they're given last names that are randomly made up, but that allude to a tribal origin. So we have Lizette Cree, Madeline Soto, Louise Belly. All of these names allude to a tribal origin. We have snakes, we have all sorts of tribal origins. Start finding out who those tribal people were and what the context of their history was at the time that union happened. And of course you have all of the daughters. It's that woman that is often not identified, but the children are. And so we can't ignore the daughters. We have to stop ignoring the daughters.
And I think one of the things that comes out of the research from my presentation or from Brenda's is that the documentation, the sources need to be started. And work that we find it quite exciting because we do a lot of these cases going, I want those maps in court, because when you're trying to describe this community, we have only very linear models. So I think one of the exciting areas of Métis research is that we're having to, I wouldn't necessarily say tease, we're having to look at the sources we have in different ways in order to try to figure out and understand these people. And it's not in black and white. I harken back to the one proponent I went to going, look, we've looked at these Hudson Bay Company records and we do not see Métis people in them. And I guess that's the same sort of thing. That woman is faceless or unknown, but the reality is that if you come at it from a different way of looking at it from a polity and looking at it through the children, you can try to get it. And I think that's one of the exciting areas that we're trying to get, that Métis research is, I think, pushing it a little bit more. It was very easy in the Indian context because a lot, we were in the Blackfoot world, and for the Hersecorn case that we're currently doing, everyone was fascinated about the Blackfoot. Tons of people were writing about them, and that's what the sources are largely dominated for. But the reality is that there's another people there. You have to look at the sources in a different way in order to find their narrative, in order to find out about them. And I think that's one of the, I find it one of the interesting things of one of the challenges of Métis research, but also one of the exciting ways of going back to old sources that have been looked at 100 times before, but looking at them in a different way and coming up with different conclusions or findings.
So if I understand it correctly, the Powley decision changed the definition of Aboriginal rights from customs and traditions prior to contact to effective control. So what would be on the North Shore of Lake Superior and maybe further west to Fort Frances and Kenora, what would be the time of effective control for Northwestern Ontario?
We think 1850 to 1880.
1880. I think here's the thing. In all of the cases, what we have to prove is that you were here before effective control, right? There is no question that we meet that test of there. Even if the earliest date of 1850 was picked, which I don't necessarily think is correct, because you actually have to look at, yes, the treaty was made, but when does things start happening on the ground where the lifestyle of the people on the ground is actually changed, right? And that's not changed when one guy comes through and says, I take this for Her Majesty the Queen in the name of England. It's actually, when do they affect their laws, and when does that they're no longer what they were, without the other external influences. So in this area, for the Métis, they're here well prior to 1850 anyway, so it becomes kind of a, it's not that it's a moot question, but it doesn't really become as much of the driver as it may be in other areas where effective control came earlier or effective control comes later. But we say that, you know, clearly by 1870, 1880 in this area, you've got, you know, you've got clear
They'll
effective
start
control.
looking in 1850 though, and they'll start looking in 1850 because that's the date of its treaty,
Yeah.
and that effectively extinguishes the Indian rights and gives the crown ownership of the land. So that would be their first grab of control. So they would start looking then, but then you would start to, but it's never just a hardline date, right? You're really looking at when people's lifestyles start to change. And the whole purpose of those tests is only, I used to call this the Kodak moment, but there's probably people in this room who don't even know what Kodak was. It was a little film and Kodak went bankrupt. And anyway, what it was, the whole point of the contact test and the effective control test was because the court was looking for a view, a window, so that they could just look, because remember these are Aboriginal rights, right? So it's before the colonizers come. So they want this window to go, okay, what were you doing? Where were you? What were you doing? Who were you at this period of time? And so that's why they put in contact for Indians and then effective control. So I mean, that's why it's a big wide open window. It's not just a one date. It's just to give them a view. Okay, in this area, we're the Métis here, and what were you doing? That's all it's about. So that's why we think it's a 30-year period.
And I think it's the principle that, you know, the Métis fit into it, that they were here first, that they were an Aboriginal people in possession on the land as well. It's not that Métis get to go and create new communities anywhere they want after effective control. It's that they were here first. That's the underlying principle of Section 35. And so that's really what they're looking at, is are they, you know, not a new construct in 1990 created, but is there a history there of those people on the land in possession?
Thank you.
I just wanted to comment on the topic where we were talking about the idea of purity, and how that that need to identify with a measurable blood quantum of Indian ancestry, how that comes out, and how that seems to be coming out more and more and more in our consultation processes with proponents and trying to understand, and that constant question of, well, how much Indian are you? And
my elbow is.
Yeah. Well, and I find that even that confusion rolls over to, as our speakers well enough know, and the other guests, for those that maybe they don't realize it, is that even for those leaders and those community members that are elected chiefs and are identifying as Indians, do actually have that Métis history, Métis, that mixed blood ancestry, but you know, the definitions of the Indian Act and who's, as it changes constantly, how that changes. And when you have, I mean, and just a reminder that for some in the room, that when you have some of those leaders sometimes that disregard the existence of Métis people in the communities, and I'll take Thunder Bay for an example, that it gets to be a difficult argument because everybody seems to want to measure it by your amount of Indian blood, and it's really, it's something that we really have to, and sometimes, I mean, I find myself caught up in that argument. You know, you get sucked into that argument and you're trying to justify your verification of your identity, for the lack of a better term right now. And I find, especially locally, because that's where we're doing this, is that it's a constant, everyday verification to whoever you speak to of who you are, what we are, and us as a nation, and our rights cycle attached to that. So and I just had this conversation the other day because somebody needed a letter from the American government, a Métis citizen needed a letter from the American government. Senator Bob and I talked about this before, to give the Indian blood quantum before you can get any kind of recognition in the state. So it's an idea that we hang on to that is something, I think, and correct me if I'm wrong, derived maybe from the Indian Act in that identity of purity, I guess. So it's all over.
Well,
so.
think about the word. Well, you know, in the Francophone community I grew up in, we were Michif, right? We didn't call ourselves half-breeds. We weren't called half-breed, we were called the Michif. But for the English, you were half-breeds, right? And so just think about that term. You know, we don't breed people. We breed animals, right? And so guess which half of you half-breed you, guess which half of you is the animal? It's obviously not the white part, right? No. And so the whole concept of purity and blood lines and all that stuff is just embedded in everywhere we go in this conversation. So, I mean, it's better to face it.
You know, I think what you pointed to is something really interesting, and my friend Chris calls it the elephant in the room is that Indians are equally as mixed as we are. Canada does not have a blood quantum structure. It's kind of worked out that way, but we don't go by 1/4, we don't go by 1/8, we don't go by 1/24. That's an American system, and it's creeped into our language, and it's become the point where people become fixated. And so we need to stop saying that the definition of Métis is about mixed ancestry or mixed birth. We have to stop saying it. We have to eliminate that from our own vocabulary because it's not about that. It's about our family, it's about our communities, it's about our land.
Which is what we did in the definition we said you're a descendant of the historic Métis Nation, right? So to get away from that exact
And so we have to stop using that language in our own conversations. It's irrelevant. And if we're going to have that conversation, well, let's start talking about everybody else's ancestry because we know that.
But don't you find that the government, even under the duty to consult, forces us to use that language?
Well,
In some regards?
They want us to, but we don't have to engage in that debate.
And I think one of the challenges that the Métis face, and it's kind of the issue of, you know, the time has come, is that one of the challenges is that everything's set up for, you know, this was the case that we recently, you know, recently before the Supreme Court of Canada, is the Indian Act vortex, right? Everything's driven around that, and you touch it, you get sucked into it. And the problem for the Métis, and for example, even the Métis settlements in Alberta, which are a land base for Métis, they get touched by it, they get confused by it and sucked into it as well. And I think one of the challenges for the Métis, one of the things that has to happen for the Métis genes, talking about those institutions, the problem that we have right now is those institutions aren't, to a certain extent, as recognized by government as the First Nation ones. And the reality is that, so the choices that people are making are not fair choices, right? Over here you have this list of benefits, over here you got nothing, but it's really the truth of who you are. And I think that until that balances out and those institutions allow people to make choices that are not based upon an economic benefit or a soul, that's the only way that you're going to have that rebalancing to some extent, and I don't think we have it yet.
And we're not going to get it.
You know.
No,
I don't think
we're not. The government is never going to. So the only way it will even out is if they remove all the benefits that the Indians get, because you can bet whatever you want. They're not going to give them all. Look what's going on. They're cutting everything. There is no way they're going to add benefits. We're not going to get health benefits and all the other things, land claims agreements, all that kind of stuff that we're going to get. What's more likely to happen is they'll ratchet down the Indians, and then we'll all be equal in our absolute inability to have any benefits at all. That's a very, very pessimistic.
Well, let's take one more question.
You know the age-old saying, if you can't fight them, join them. At what point will Métis, Aboriginals, or anyone actually come up to the government level and say, okay, well, create a party, you know, NDP, Liberal, whatnot, and actually say, you know, if you can't, well, how can you govern this country if you don't understand its actual people? And like, why are they not learning actually about the Métis people, the Aboriginals, and what we are, and able to make laws and things about us?
They don't want to. But first of all, we have a problem that we're not a political force to be reckoned with. That's a big problem. Most Indians don't vote, right? So most Inuit don't vote. Métis do vote, but we don't have the numbers and they don't recognize us as a voting bloc, right? So they discount us as a political force. So that's one answer to your question, why they don't bother, because they simply don't have to. And the only reason they're paying any attention at all is because we're going to the courts and the courts are making them pay attention. Otherwise, they will just happily ignore us, which is, that's the good thing about litigation. You might not always get what you want, but Aboriginal people, by and large, have been pretty successful in getting the courts to crack those over government. But the problem we have is that government simply refrains from acting then. They don't take positive action. So they don't bend their rules and regs and do things like that. All they do is stop doing things that hurt you and hope that you will not push them to do anything further. So we have a negative response from them as opposed to any kind of positive response.
I think going to that, one of the statistics that scared me when actually someone said it was that in a span of, I think it was 18 months, Canada brings in the same population of people into Canada as the entire Aboriginal population. And so when you actually think about that, as far as where the growth is coming from, it's, thank goodness we have things like Section 35, and because people have very, very short memories. And I think through litigation, but also through the work of Métis Nation of Ontario and the things that you do in your communities, we force people to remember of kind of going, no, there's a story here that still needs to be recognized, respected, and reconciled within how we go forward. But it becomes harder and harder. But I think we have to use whatever tools are available to us. The courts are one, creating our own institutions are another, partnering with educational institutions to make people recognize more and more, and to carve out spaces of how we can continue to exist as distinct Aboriginal peoples.
Okay, we do have one last question.
Just a bit of a loaded question. I guess despite the progress we've made today in doing your research, you found that racism and fear still play a barrier to taking advantage.
There's no really way to elaborate on that one except to say yes, racism, and it's not like we're not within it, that we don't have it within our own rights either, but because of the way the world works right now, Canadians are not uninfluenced by that, and not to say they don't participate in it themselves. So we know that. I think we've been watching on the news this Norwegian guy went out and shot up those people. That could have happened here. Could have happened here just as easily. So I'm not sure that we don't. What?
I said Jean took her happy pill today.
Thank God there's a reception.
Give that woman a drink.
Okay. I'm sorry, but we've had that happen in this country before, and I don't think that we should ignore it. But it is the issue here is it's people don't understand, right? We're trying to carve out special rights and recognition, including land rights, for Aboriginal peoples in this country. And the people who came later, who've been here, some of them for hundreds of years, don't get it. They don't see why. They say, well, I've been here for hundreds of years. Why do you get something that I don't get just because, what? And then they usually say, because you're a different color than me. Well, it doesn't have anything to do with color. It's really a fairness idea. The people who were here first shouldn't lose what they had because of the newcomers, right? Now, we realize that we can't send all the newcomers home, but there's got to be a recognition that the people who were here first should be able to retain at least some of what they had before the colonizers came. This is a very old idea, right? This isn't an idea we invented in North America. This is an idea that the Romans had when they invaded Britain, right? They let the common law of the people continue to exist. So this is a very ancient concept that Aboriginal peoples are leaning on. It's really based on one concept, fairness. We were here first. You shouldn't be able to come in after and take everything we had. It's very simple when it comes right down to it. But the people who come after, well, they don't want that kind of backlash, right? They want to be able, and why not? Because they're stronger, right?
Well, I think that Canadians have a very easy time ignoring race. We say that the Americans have race. We don't have race. We have multiculturalism. They had the melting pot. We had the mosaic, right? right? And so that if we never honestly discuss race, and not that there are races, but that we have created and constructed a society predicated on race, whether it's the color of your skin, whether it's the country you came from, then you never get at fairness, because you continue to deny its existence. And I'm not saying that people are racist. It's a conversation about an intellectual construct that divides people more than it actually unifies them. And if you can't discuss it, then you can't address it. And Canadians don't discuss it.
Great, well, we can continue with this discussion at the faculty lounge. But please join me again in thanking all of our panelists. I'd now like to call upon Senator Barbara States to make a closing prayer for
It's so bad, watch out for that wet ice.
Only I like this when I get to say the last few words. I'm going to make a little comment, I'm going to go back to about 1606 in Eastern Canada, in the first little, when Champlain's decided to set up a colony, and his men took the Aboriginal women for a wife, and had these little children. And these little children grew up, and Champlain said to them, "Go west, young man." And then when they were traveling away, getting west, he says, "Oh, I forgot to tell you, go west and multiply." Here we are. I'm going to carry on with my prayer. Great Spirit, take kindly to the counsel of years and experience of our elders, graciously surrendering our youth in many things of the past. We would not be here without them. We will continue to build our strength and spirit to protect and shield us when grief arises, as we encounter any sudden misfortunes through our lives. A clear, strong, and nurtured mind will overcome and conquer many of our fears, which are often the origin of our unhappiness, fatigue, and loneliness. We will discipline ourselves to be outstanding and proud people who will leave a mark of excellence in today's society, to carve our path, to guard our siblings and the next generation of peoples. We must stand together as a nation and be proud of our heritage, and be kind and gentle to our brothers and sisters. We are a family of Aboriginals in this great universe who stand equal to others on this earth. We give thanks to our Creator for the great gifts and wisdom He has given us. Amen. With which mercy and thank you. And everybody have a safe journey home to your loved ones, and God bless.
I can take them. I'll take them. I gotta take them to the faculty lounge. Oh, neat. Aww.
18 here. There was 2 in Ottawa. Watched the whole thing.
Aww.
Excuse me.
Is it the same place where we had that discussion that night?
Well, I know where it is.